Welcome to this week's Property Elite podcast. Stay tuned each week for industry hot topics, market updates, and new RICS guidance. In this week's blog, we look at the DUAA. This is essential knowledge for all qualified surveyors and RICS APC and Associate RICS candidates relating to the data management mandatory competency. So what's new? The DUAA amends the Data Protection Act 2018 and UK GDPR. It aims to streamline how organisations manage and process personal data, to provide clarity over interpreting existing legislation and regulations, and to encourage innovation in data management and data protection. Here are some of the key changes: subject access requests, legitimate interests, automated decision making, data protection complaints, and privacy and electronic communications. So what has changed relating to SARs? An SAR is a request made by an individual under the right of access to obtain personal data held by an organisation. This will include confirmation that personal data is held, a copy of the personal data held and any supplementary information, for example purpose, data category and retention time. An SAR can be made verbally or in writing to an organisation who must respond within 1 calendar month or 2 months for a complex request. No fee can be charged for responding to an SAR, and it can only be rejected if it is vexatious or excessive or an exemption applies. For example, the information would disclose the personal data of another individual. The DUAA allows organisations to temporarily pause the 1-month deadline to request clarity over the SAR or to verify the individual's identity. It also clarifies that only reasonable and proportionate searches are required to provide the requested personal data. What has changed relating to legitimate interests? Previously, there were 6 lawful bases under which an organisation could use to process personal data: consent, contract, legal obligation, vital interests, public task, and legitimate interests. Prior to the DUAA, if an organisation wanted to use personal data for legitimate interests such as fraud prevention or marketing, then a 3-part test was applied. First, purpose. Is there a valid reason for using the data? Second, necessity. Is holding the data the only reasonable way to achieve the goal? And 3, balancing test. Do the organisation's interests outweigh the individual's right? For example, the data should not be unexpected or cause unjustified harm. Under the DUAA, a 7th lawful basis has been introduced, known as a recognised legitimate interest. This relates to specific high-priority activities within 5 categories: crime, safeguarding, emergencies, national security and public task disclosures, which preclude the balancing test element of LIA. The reason for this is because the government considers that this has already been satisfied at a legal level, and this allows organisations to proceed quickly in certain circumstances. The DUAA also clarifies that direct marketing and intragroup administrative transfers are defined as legitimate interests, although not recognised legitimate interests, thus still requiring a full LIA with the balancing test being applied. What has changed relating to ADM? For automated decisions made by AI, the previous position was that an organisation could generally not make a solely automated decision using AI about an individual if it had a legal or material impact, for example a job application. Automated decisions were only permitted in very narrow circumstances, where it was under contract, allowed by law, and explicit consent was given by the individual. Under the DUAA, organisations can use any of the lawful bases mentioned earlier to make significant AI-based decisions, provided special safeguards are applied. These 3 safeguards relate to transparency, the right to contest, and the right to a human review. If special category data, i.e. sensitive personal data, is involved, such as health or religion, then the previous position still applies. What has changed relating to data protection complaints? A new statutory right to complain to an organisation's data controller has been introduced. The complaint must be acknowledged within 30 days and investigated without delay. What has changed relating to privacy and electronic communications, PECR? The DUAA has removed the requirement to obtain consent for non-intrusive website cookies, for example for the purposes of website analytics or emergency alerts. The soft opt-in rule for text and email marketing has been extended to charities who can now message individuals unless they opt out, rather than having to opt in as per their previous position. maximum fines under PECR have been increased from £500,000 to align with UK GDPR levels up to 17.5 million or 4% of global turnover. Thanks for listening to this week's Property Elite podcast. Head to our website to check out the full blog, and here you will find free and paid support resources and services. We offer a free consultation for every single RICS APC and Associate RICS candidate, or you can ask us any questions you have via the online chat. See you next week.